Hearing in Taiwo and Olaigbe and Onu against Akwiwu.
Yes, Mr. Allen. Can I just begin by saying how grateful we are to you for agreeing that the hearing tomorrow, should it be necessary, can be in the afternoon rather than in the morning. You will be aware that there's quite a well-known case which we have had to insert into the list at very short notice, and because the President is not available tomorrow afternoon, we're having to put it in tomorrow morning. So we're grateful to you for being so accommodating. Thank you.
Thank you, my lady. I think we were all thinking that might happen when we saw the announcement of the judgment in the Court of Appeal. May I start by just introducing shortly the participants at council level. As you know, my lady and my lords, this is a joint appeal in the case of Taiwo and in the case of Onu.
Well, strictly it isn't, Mr. Allen. Strictly, Onu does not yet have permission to appeal.
That was down my list of things to say to you. But they are, Mr. Onu is represented by me together with Mr. Rowbottom. Yeah. And the Akwiwus are represented by Mr. Rahman and David Mould, who sit to my immediate left, your right as it looks from here. And I think it's right to say that they have taken on the responsibility of that part of the case at very short notice. I don't know if this has percolated all the way through to my lady and your lordships, but in the Employment Appeal Tribunal and in the Court of Appeal, the Akwiwus were represented by Mr. Jake Dutton. And very sadly, shortly after this case was, as it were, put into the list at the beginning of this year, he was diagnosed with cancer, and the process of agreeing a statement of facts and issues was therefore delayed in Onu, and very sadly, very unexpectedly, he died in March, and that's why they've had to take on the brief at very short notice indeed.
Well, we're very sorry to hear that, Mr. Allen, but very grateful.
It's a great loss. I mean, he was... I considered him a professional friend, and it's sad that that has happened. But you need to know that. So if any slack has to be cut to the Akwiwus in relation to that, there's good reason for it, as it were.
It's not apparent on what we have in front of us. It's not apparent that slack needs to be cut.
No, but it's right that I should tell you that.
Thank you.
I, to my right, have Mr. Milson and Mr. Rowbottom. Mr. Milson represented Ms. Taiwo in the Employment Tribunal, and Mr. Rowbottom represented Ms. Onu in the Employment Tribunal and at every stage thereafter. Mr. Rowbottom's kindly allowed me to lead him in the Supreme Court, but he represented Ms. Onu himself in the Court of Appeal. And to my left, you will know Mr. Linden, who represents the Olaigbes, together with Sarah Hannett, both of whom are new to the case at this level.
Well, we were very grateful to Mr. Linden for agreeing to take
the
case at a time when it wasn't at all clear whether that would be at his expense or somebody else's.
Absolutely so. I want to just say a very short thing about housekeeping, too. Partly because if I can take as read my lady's point about whether Onu is fully in front of the court, there are two sets of papers in front of you. You will have an MS bundle, which I think is on the computer already, and that should be clear. And there's a bundle also, which is not quite in such good order, but it's not bad in the Onu case. I will refer to the page numbers electronically as MS numbers for Taiwo and ordinary numbers for Onu. You may like to note for your own notes that the authorities start in the Taiwo bundle at MS 500 and in the ONU bundle at page 567. So that's just for your convenience of when you get into the authorities. There is a small supplementary bundle which should be on the bench, and if it isn't, I know that the usher has got them and will be able to hand them over. And if I can just take a moment to tell you what's in that, so that you will know. If you could turn to it, it's just a stapled bundle, I think. I don't know quite how it was handed up onto the bench, but it was in stapled form. Have you handed it up at the moment? It should simply say Appellant Supplementary Material Index.
Yes.
And you will also find a document with a yellow tab on it, which is something which I thought this morning you might want to see. The Supplementary Materials Index I will be referring to. There are two bits of it which will be particularly important, I think, which are tab 1 or bit 1, some provisions of the Race Relations Act that for some reason or another got omitted, and 5, which is the document handed up to the Court of Appeal, the memorandum prepared by Mr. Milson about the effect of the immigration rules, and I shall take you to that shortly. And then the other document with the yellow tab on it is Section 23 of the Immigration, Asylum and Nationality Act 2006, which is the provision that provides for a code of practice in relation to the employment of persons who are subject to immigration control. And I will take you to that in due course when we get to that code of practice. So those are supplementary matters that I need to bring to your attention. I also need to tell you, although I don't think this will affect in any way the process of argument today, that there is a cost capping order that's been agreed between Ms. Onu and the Akwiwus, essentially that neither side will seek costs against the other in that appeal. Now, the issue in the two appeals has been put at the highest level in exactly the same way. The overarching question, as you will have seen in the notice of appeal, the application for permission to appeal in each case, is mistreatment of a person because of their position as a vulnerable migrant domestic worker reliant on her employers for continued employment and residence in the UK, contrary to, I think it's actually just said the Equality Act, but one should read into that the Race Relations Act 1976 and or the Equality Act 2010. For your notes, that's MS 14 in the Taiwo bundle and page 14 in the ONU bundle. You don't need to turn that up. Both appellants, as you will have seen, came to the UK as foreign domestic workers on special one-year visas. And in the Court of Appeal, Lord Justice Underhill accepted that in law this would give a degree of control to the employers over the employees. The reference, which I will take you to in a moment in the Court of Appeal judgment, is MS page 153. And he summarised a note from Mr. Milson, which is the document I've just mentioned, 3 in the little additional bundle. And I would like to just take you to that shortly to show you how that was summarised for the Court of Appeal and accepted by the Court of Appeal as being a fair summary. I shan't read all of it to you, but you'll get the shape of it. It's the last part of the bundle, and the front page says Memorandum, the Immigration Rules Concerning Migrant Domestic.
What's the number, Mr. Allen?
It's the last tab of the new bundle, so it's tab 3.
I don't have tabs on.
I don't have it paginated, I'm sorry.
We've got pagination, but no tabs.
Try 1298.
1298, I'm told.
It's tab 5, not tab 3.
My mistake, I'm sorry.
Forgive me for spraying questions at you about numbers, Mr. Allen. Paragraph of the Court of Appeal?
The paragraph in the Court of Appeal, I'm sorry, I've just turned my notes away. The paragraph is 25 in the Court of Appeal's judgment, and it's page 153 in the MS bundle. I'm sure it will be more convenient for you to read this at leisure, but if I can take it through very quickly for you. There is a distinction between the position prior to the 6th of April 2012 and after. We are concerned with the position prior to the 6th of April 2012. This document covers both situations. You will see in paragraph 4 the qualifying requirements for entry clearance are in paragraphs 159A to H of House of Commons paper 395, which I suspect this court has at some stage or another looked at in other cases. There's an age restriction, and then B, which will be important when we look at the facts later on, the applicant for the domestic worker visa has to be employed by the sponsoring employer for a minimum of 12 months to ensure that there's a genuine existing, have been employed, to ensure that there's a genuine existing employer-employee relationship. Although there's a query about whether a shortfall might not be an absolute bar to getting that visa by reference to the Border Force Operations Manual, that's BOM. But there certainly has to be some prior connection of working under the same roof, which is in C. There's a travel obligation, which you'll see on the next page, travelling with the employer. A certification obligation. And the employer's got to sign certain statements. And importantly, at G, an entry clearance endorsement was a mandatory requirement, although the endorsement shouldn't give the employer's details. So there has to be an endorsement of entry clearance. And then you can see the conditions for entry are set out in paragraph 5. And I can just ask you to run your eye over those without reading them all through. And then you'll see at pages 4 and 5 that there are some quite considerable difficulties in changing jobs once entered, although it's not absolutely impossible. And eventually it can possibly lead to indefinite leave to remain. So those were the controls, in summary, that operated, and which are summarised by Lord Justice Underhill giving the judgment of the Court of Appeal. We know that there are of the order of 18,000 domestic service visa applications a year, although not all of those will come into this country immediately. They may come at some later stage. And not necessarily all of them will come ever. But there's a substantial number of people that do come to the UK under the domestic service visa process. We know also that that process can be subject to abuse. As I've mentioned in the case, at least I think a third of this court was in the Hunger case 2 years ago. That's tab 4, MS 1628, volume 4 of the authorities at tab 46. And I'll just open that for a moment, although I shan't spend any great time on it. And if you could just look at that. This was a case in which Lord Wilson, Lord Hughes and Baroness Hale were involved. The judgment was given by Lord Wilson.
Tab 4, but I think it's tab 46, isn't it?
I hoped I said that. Did I?
Or
say something
perhaps
different?
I'm getting hard of
Tab 46 in volume 4.
Right, thank you.
Most members of the court will have had occasion to look at Hunger for the purpose of that which it decided.
The reason I'm mentioning it is it doesn't determine this case. It was raised in the case.
We didn't let them argue it.
Well, my lady, you remember that point.
Of course I do, yes. Nor do we really need persuading that there will be migrant workers, migrant domestic workers of this sort who are vulnerable to
Of course not.
exploitation and ill treatment, and some of whom will have been trafficked in the classic sense. We do not need persuading of that.
I'm not going to labour this point, my lady, but I felt it right to draw it to your attention because 2 members of this court would not necessarily know that. The point that we have made in the case, in both parts of the case, are that the facts of these 2 women are actually very similar to those in Hunger. Not identical, but very similar. What is important, though, is to look at the precise details in the 2 ET judgments as to how each of these were dealt with. And that's where I want to go next, shortly, to summarise that. If you could pick up, please, the core bundle in Taiwo and go to page 233. The conclusions that are the foundation of the appeals in Taiwo, because Ms. Taiwo didn't succeed at first instance on the discrimination claim, are to be found in paragraph 26.7.
Are these accurately summarised in paragraphs 14 and 15 of Lord Justice Underhill's judgment?
My Lord, we don't have any particular criticism of that at all. No, we don't. As I've said in our case, we think Lord Justice Underhill, his judgment went wrong at the second question that he posed. We had no particular criticism of the way that it had been summarised. I'm sorry, is there a subtext to your question?
Well, I just wondered whether we needed to know more of the facts than in that helpful statement of the facts in each case in the Court of Appeal's judgment.
My Lord, I'll take it more quickly, but I felt I had to show that part of it. Certainly.
Mr. Allen, we've got the Employment Tribunal judgment in the core bundle. We've also got it in what's called Appendix Replacement Item 5, and I didn't quite know why we had it in both places and whether there was some sort of error in the earlier version.
There is. And the answer is that there's a missing page in the core volume. So if you are, electronically this has been corrected, but if you, in the core volume, if you could go to MS 229, you will see that a page of the judgment's been omitted. It goes from paragraph 17 to paragraph 25.
Oh, yes.
And
So if people are using hard copy, they should be using
exactly.
this.
That's what I wanted
That's
to
what
understand.
you wanted to know.
Thank you.
Those of us who are using
electronic, you'll have it corrected. Good. And picking up on my Lord Toulson's point, I need only tell you, I think, without opening it. Well, I do actually want to just shortly open it because it's slightly more extensively put. Let me put it another way. Lord Justice Underhill has slightly over-abbreviated the ONU judgment beyond that which I want to do. So if you will open the ONU bundle at page 252, which is the first of the 2 white volumes, and it's page 252 in the electronic version. The findings which ultimately led to Ms. Onu succeeding on the race discrimination case really flow through from paragraphs 118 to 124. And in my view, they've been slightly over-summarised by Lord Justice Underhill.
Page 252, I think, is submissions.
No, you'll find in paragraph 119 in the tribunal's judgment.
Well, my
I'm in the same position as Lord Reid.
Yeah. Yes, there are respondent submissions start at page 243 and 252 is in the middle of those.
I think we may have a discrepancy between hard copy and electronic copy.
Is my lord looking at numbers in the top right-hand corner or the bottom left-hand corner?
Neither. Bottom right.
252
right.
is undoubtedly part of the judgment, the reasons, on the electronic bundle.
My lord may
You're with me, my lady, am I?
I am, but I'm probably alone.
my lord may find paragraph 118, which for some of us is the best reference, but not for everybody. At 115, bottom right.
This is the point at which I
yes.
take a deep breath. And
Yes.
I hope it gets
Thank you.
better.
Yes.
And I won't even begin to summarise Lord Justice Sedley's rule of page numbering at this point either. But paragraph 118 in the judgment, which if my Lord Reid finds page 115, I can understand too. Again, I don't propose to read all of it, but the findings that are relevant to the conclusion are between 118 and 124. And you'll see that the detriments are set out. The submission from Mr. Rowbottom, its facile suggestion that the respondents would treat an employee of UK national origin, lived and worked within the UK in this way, and the first and second respondent accepted in evidence, they would not have done so. In the tribunal's judgment, so far as ascertaining whether the claimant was treated less favourably, they then went through the Mehmet approach and then wondered whether they had to go through the reversal of the burden of proof approach in Ijen and Wong and Madarasi. The explanation from the respondents for the treatment was that this was a Nigerian contract performed in accordance with Nigerian law, and that the claimant was paid more than the national minimum wage in Nigeria, and that there was no intention to discriminate by the respondents who didn't contemplate that what they were doing was unlawful in Nigeria, even if that were the case. This had no bearing on the subject, said the tribunal. Well, in one sense it did and it didn't, as you'll see. In the tribunal's judgment, this explanation, even if it made out in its facts, could not possibly discharge the burden of proof. Questions are, what was the reason for the treatment? Was it in no way whatsoever on the grounds of race? In the circumstances, the employers in this case have fallen far short of proving that the treatment was in no way on the grounds of race. The reality is that they treated the claimant precisely in the way in which they did because of her status as a migrant worker, which was clearly linked to the claimant's race. Burden of proof passed to the respondents, and they've not discharged it. And then they make the finding in 122, and then the next bits deal with the approach taking to indirect discrimination, and then the harassment finding is in 124, applying the same reasoning as before, her treatment as a migrant worker in particular, in the retention of her passport, and the threats and abuse that the tribunal has found took place in this case, undoubtedly for the same reasons as before on racial grounds, amounted to unwanted conduct, the effect of creating an intimidating, hostile, degrading, or humiliating environment for her. So I've set it out a little bit more fully there than you will find it in the judgment in the Court of Appeal. Now, each of the two judgments set out the background to the control exercised by the employers over the two women by reason of their passports and the visas under which they'd been admitted to the UK. In both cases, the passports were retained, and the control over the individuals lay in the terms of the visa that was granted and the retention of the passports. It was exercised in slightly different ways I don't know that it really matters to get into the full detail of how it was exercised, although it's perhaps most grossly obvious in the Onu case, when there were threats by reference to the television programs and so on about what would happen if Miss Onu was to seek to escape. The two statements of facts and issues set out in much greater detail the pressure that was applied to each individual. So that brings us to the relevant law, then I need to just give you some dates because although in the end it won't make any difference to the way the judgment is determined, it provides the context. Ms. Taiwo came to the UK on the 9th of February 2010 and didn't escape the Olaigbe's clutches until the 6th of January 2011. So her case crosses the date, the 1st of October 2010, when the Equality Act came into effect. Ms. Onu's case falls to be considered under the Race Relations Act. She entered the UK on the 29th of July 2008 and left the Akwiwu's household on the 28th of June 2010. All the dates are set out in fully accessible form in the SFIs in both cases. Although there's some difference in the text of the provisions providing for indirect discrimination in the Race Relations Act and the Equality Act, where the ground relied on was nationality, all parties agree that there's no essential difference as between them. I don't know if I need to turn up the text for you. It's set out in many places, both in the cases, but for your notes, the Race Relations Act text of the direct discrimination provision you will find at MS 500. What that omits to say is the provision in section 78. So perhaps I can see court turning to 500, so perhaps I can just do that with you for a moment. It's the first tab in the first volume of authorities. It will, I'm sure, be familiar to each member of the court. A person discriminates against another in any circumstances relevant for the purposes of the provisions of this Act if, on racial grounds, he treats that other less favourably than he treats or would treat other persons. And racial grounds is defined over the page in section 3, and you'll see it includes colour, race, nationality, or ethnic or national origins.
And your basic task has to be to persuade us that migrant status is a proxy for
It's an aspect
race
of
as so defined.
Exactly. And that is that's the core submission, as you'll have seen from my case, that we make. And one step on the route to that is section 78 of the Race Relations Act, which you will find in the small additional volume. And this is where I'm hoping Lord Wilson will help me with page numbers, but it's the first
1285.
I'm so sorry.
1285.
I'm grateful. 1285. You'll see section 78 has been included, and that tells us that's the general interpretation provisions, and if you'll turn over the page, nationality is defined to include citizenship. It's just below the second hole punch, if you've got a hole punch, 2/3 of the page down. Is my lady with me?
Nope. Oh, yes, I am now. We don't have hole punches.
I'm sorry, but
there we go.
2/3 of the page
I have
down,
found it.
I've got it. There's a history to that, which I will take you to very shortly. It's an amendment that was given effect. In fact, I can deal with it quite shortly now. It's an amendment that was given effect to in consequence of the omission of nationality in the 65 and 68 Race Relations Act. And that led to a piece of litigation called the London Borough of Ealing, which is referred to in the
I'm
case.
sure we're all familiar with that. You referred to it at length in your case.
While we've got this authorities bundle open, the command paper, which is section 4 of that mini bundle, explains how the inclusion of nationality and the inclusion of citizenship was intended to make up for the default that was found in the Ealing case. It's paragraph 56 in the command paper. I really don't need to spend time on that at the moment. I do need to tell you, though, that the Equality Act does not include expressly the cognate provision to section 78, the definition, but it's always been assumed that the Equality Act was intended to simply replace the provisions of the Race Relations Act. And I don't understand, it will be submitted to you, that the Equality Act now excludes citizenship from nationality. But you need to know that that happened.
Mr. Linden is shaking his head.
He understands correctly. It won't be submitted.
Good. I don't need to open them, but for your notes, the Equality Act is set out at MS 513, which is tab 3 in the first volume. You may want to also just shortly look, though, at the provision dealing with harassment, and that is the first part of the supplementary bundle, section 3A, at 1277. And it's sometimes said that this is a non-comparative provision. It's concerned simply with injury to dignity. A person subjects another to harassment in any circumstances relevant for the purposes of any provision referred to in section 11b, where on grounds of race or ethnic or national origins he engages in unwanted conduct, which has the purpose or effect of violating that other person's dignity or creating an intimidating, hostile, degrading, humiliating or offensive national environment. So it's where on grounds of, that does not at the stage of the Race Relations Act include nationality, only national origins. It was introduced to give effect to the race directive, which didn't extend to nationality. Under the Equality Act, it has gone the full distance and there's no distinction made. Now the principal submission. As my ladies anticipated, we say this is direct discrimination and harassment that these two women have suffered in their employment. And although an alternative case on indirect discrimination has been advanced in relation to Ms. Onu, I stand before you not saying that's what I believe this case to be about. I don't. I think this is a case of direct discrimination.
Or nothing.
It's direct discrimination or nothing. I think it's to try and shoehorn a set of facts into something which indirect discrimination is not intended to cover. There's quite a neat way of making this point. I'm sure all the court are familiar with arguments about what is direct and indirect discrimination. But there's a passage which I'm very fond of, which I'd forgotten to put in the case, but which is, I think, worth citing, from the Advocate General's opinion in Coleman and Attridge, which was the first associative discrimination case. I did cite it in Jewish Free School to my lady, but for reasons I can't explain, I failed to put it into the case here. If you could turn to volume 2 of the authorities, you'll find, I hope I got that right. Sorry, the ONU authorities. It's not in the. It's in the. It's in 787. Is that the second volume? Yeah. 787 of the second volume in the Onu case.
Yes.
Common and Attridge is the case in which the Court of Justice decided that the Equality Directive 2000/78, which provided for protection against disability discrimination and age and sexual orientation and so on, also protected in a context called associative discrimination. Miss Coleman not herself being disabled, her son being disabled, and she being harassed by her employer by reason of her son's disability. The question whether that was within the scope of the protections in European law. And Advocate General Poares Maduro discussed how how indirect and direct discrimination interact in a passage which I think is worth reading at paragraph 15 onwards, page 793. I don't propose to read all of that to you, but if you could note for your notes, pick it up at page 793, paragraph 15.
We don't have, at least those of us working from hard copies, don't have these page numbers.
In which case, it's 1134 of the report.
Yeah.
Paragraph 15.
The bundles are, it's nobody's fault necessarily, but it is very difficult to find the right
I'm
bundle.
so sorry.
This one calls itself Supplementary Authorities Volume 6. At least my copy of it does,
That only goes to divider 7. We're looking at
which is what you want.
Well,
Which is what I
tab
want.
7,
Oh, 7 is
tab 7 is 13.
Great.
right.
That's what my volume looks like, which is obviously different from everybody's.
I'm afraid it is. You just need to know that.
Anyway, I don't think we'll be citing much, I won't be citing much authority from this volume, but it's quite a neat passage.
You want the Advocate General paragraph
The Advocate General
15, is that right?
starts at paragraph 15 on page 1134.
Yeah.
And you'll see at paragraph 16, the important words here are on the grounds of, and you'll see there the discussion that ensues from that. I don't propose to read it all to you, but I do recommend it to you. And then over the page, at 19, there's a passage I do want to read, which is the paragraph 18. In the sense described above, the directive performs an exclusionary function. It excludes religious belief, age, disability, and sexual orientation from the range of permissible reasons an employer may legitimately rely on in order to treat one employee less favourably than another. In other words, after coming into force of the directive, it's no longer permissible for these considerations to figure in the employer's reasoning when she decides to treat an employee less favourably. I think this concept of an exclusionary function it perhaps hasn't made its way into the UK case law quite so explicitly, and I think it's possibly helpful in this case. Although this is discussing Directive 2078, of course, the race provisions are in 2043, and they were built on our own Race Relations Act. So this jurisprudence is just as applicable to the Race Relations Act. In 19, he goes on to say this. Directive 2000/78 prohibits direct discrimination, defined as less favourable treatment, harassment, defined at Article 3, which I don't need to read, and indirect discrimination, defined as. And then if you can pick it up just above letter E, the distinguishing feature of direct discrimination and harassment is that they bear a necessary relationship to a particular suspect classification. The discriminator relies on a suspect classification in order to act in a certain way. The classification is not a mere contingency, but serves as an essential premise of his reasoning. An employer's reliance on those suspect grounds is seen by the community legal order as an evil which must be eradicated. Therefore, the directive prohibits the use of those classifications on grounds on which an employer's reasoning may be based. By contrast, in indirect discrimination cases, the intentions of the employer and the reasons he has to act or not to act are irrelevant. In fact, this is the whole point of the prohibition of indirect discrimination. even neutral, innocent, or good faith measures and policies adopted with no discriminatory intent whatsoever will be caught if their impact on persons who have a particular characteristic is greater than their impact on other persons. And then he goes on to discuss it. Now, in the context...
You don't need an evil intent for direct discrimination either. It may be
understand.
forced on you by circumstances, as Birmingham
Of course.
tells us. Yes.
And we know that from the other cases. But the distinction between direct and indirect is very neatly put, I think, in that passage there. And it summarizes in short form why we say this is direct rather than indirect discrimination, because by no stretch of the imagination would advocate General Paris Maduro, being aware of these facts, have said this was indirect discrimination on this assessment.
Well, one of the problems is that the only sort of provision, criterion or practice which anybody could come up with was unfavourable treatment of migrant workers.
Exactly.
Which is a circular...
Which is self-fulfilling and circular. Yeah. And actually, of course, brings us back to the point, which is that this was, in one sense, targeted treatment. And factually, what these two cases are concerned with are decisions by employers to recruit migrant workers to bring them into this country. And we see that in the facts of the two different cases. So that's why the focus of my submissions are going to be on the connection between migrant status and on nationality, as we know, including the concept of citizenship. Any number of different verbs or propositions can be put together to make that connection. The way that we put it in the case is to say that the visa situation of these two women is a direct function of their particular nationality and citizenship. There are other ways they might have come to the UK, but in the context of this case, which is about the treatment of an employee as a domestic worker, they came on the only way that they could, which is through the visa which I've described. That's how they came to this country. And it's that visa which gave their employers the control that they had over them. And that's the core of the case. That really is the core of the case. They were vulnerable in other ways. They were poor. They were not very good at English, and so on. And those vulnerabilities can be looked at. But the core vulnerability that makes the connection with the Race Relations Act is this visa control. That's the link on which the case is premised.
You say that's the core of the case, but I mean, haven't you also got to deal with the fact that if we're talking about non-Britishness, there would be a lot of non-Britons who would not be subject to this sort of vulnerability?
I've got to deal with that point, my lord, absolutely. But it's a very short answer that I make to that, which is that these employers had no intention of recruiting other than from their base country. They were not concerned with people who might come here to work in a bank as moving from a bank in Lagos to a bank here. That's not a relevant situation. They were looking at recruiting domestic workers. And in this particular case, they were looking at recruiting domestic workers from overseas, not from within the European Union, but from their base countries. That's how it operated on the facts of this case. So we think, and we submit, that one part of the error in the Court of Appeal judgment is to draw a comparison on a basis far too wide for the actual context of this case. The fact that people might come to this country in other ways to do other jobs is not relevant. The circumstances within which this assessment has to take place are the precise circumstances that these employers wanted to recruit domestic workers to work within their house, servicing their children and their families.
And you have to go a bit further, don't you? Domestic workers of a particular nationality.
Of a particular nationality, being from overseas, that they could control in one way or another, yes.
Yes, because it could be, you don't mean from a particular nationality. Your point about their own community.
They have to be non-British and not able to come here on a visa-free basis. That's the point of it.
But that would apply to a lot of people.
But that's not what they were looking for. What they were focusing on was seeking to recruit within Nigeria to bring to this country.
Well, that's why I was putting it to you.
Yeah. I'm perhaps not repeating your point
particular,
back as well as I should.
That they were not only recruiting non-British workers, they were recruiting workers of their own nationality.
In one case, yes, and not in another.
That's the problem, isn't it?
Because
That's why I'm putting it to you.
I forget whether it was Miss Olaigbe or who was, one of them was Ugandan. I think it was Miss Olaigbe was Ugandan. Is that right? Yes.
But you would say that makes no difference, because whether it's Nigeria or Uganda, it's still their Nigerian or Ugandan nationality that counted, because that was why they were recruiting.
Well, the evidence doesn't come out that they particularly wanted to have somebody who is Nigerian or Ugandan in that sense, although what they do say was that they were looking for somebody within Nigeria to bring over to this country.
But your submission, as I understand it, is that the point is that they were looking for somebody who, when they came, would come on terms which gave them a control which otherwise would not have arisen.
Exactly so.
But why does that mean? Well, and that's the whole question in the case.
The whole question.
Because the reason they wanted that, because in each case they'd got young children, in one case young children and foster children, and they needed to get them to work the ridiculous hours that they did without complaint. That was the reason that lay behind that. To pick up my lady's point, it's in the judgment in the Taiwo case, it's page 233 to 234, 26.7. We can just look at that for a moment. It's to preserve the cultural heritage, I think, is the way that it's put in the judgment.
Is this in the ET?
In the ET, yes.
I wanted Yoruba. This is 26.72.
Yes. And this, I think, is what my lady had in mind when she's putting the question to me.
Well, it was intended in a helpful sense, because it does get you closer to direct nationality discrimination.
It does. Finding us that Nigeria, the claimant was not treated in the way that she was because she was Nigerian, this said in particular. The claimant was treated in the way that she was because she was a vulnerable migrant worker who's reliant on the respondents. So that's the ultimate conclusion. The way that the argument, the context within which that arises, is that they were looking for somebody with a particular cultural heritage. They weren't looking within the United Kingdom. They were looking within Nigeria to recruit. And that's the case from the respondents, and that's the way that the conclusion is reached by the tribunal. And for good or ill, that's what I'm stuck with. That's the finding of the tribunal.
In order to be prohibited, the treatment has to be, the less favourable treatment has to be on racial grounds, which we're told means on grounds of, in particular, nationality. And clearly, for the reasons that have been explained, in this case, less favourable treatment wasn't in any particularly obvious sense on the grounds of nationality. It was on the grounds of migrant worker status. And so, it seems to be what you have to do is persuade us that migrant worker status functions as some sort of proxy which is relevant within the terms of the legislation for nationality.
That's exactly right, my lord, and that's why I'm here, and that's what I seek to do. And the way I put it very simply, and I'm going to try and show you some authority to help me along this route in due course, but that's exactly what I'm proposing to do in argument. You use the word proxy. I think that's not one that I would be wholly happy with using, because proxy suggests that if one likes that migrant status is a whole approximation for nationality. I see it in a slightly different way. I say that a person's migrant status within the United Kingdom is a function of their nationality, i.e., your nationality determines how your migrant status will be approached within the United Kingdom.
That's quite an important difference, Mr. Allen. Can we just explore what you mean by function?
What I mean by that is that a non-British person of any kind cannot enter the United Kingdom except by reason of our laws applying to their nationality.
Yes.
It will apply in different ways according to the nationality that you have. So if you have a nationality of the European Economic Area, EU plus, it will apply in one way. If you come from Nigeria, it will apply in another way. And it's the function, therefore, the way our laws apply to nationality that determine what your migrant status is in this country. And forgive me, can I just finish the point, my lord, for a second? In one sense, it's a straight line relationship. It doesn't, the laws themselves determine what status you have in this country when you come in here. It's the stamp you either need or don't need on your passport, and the content of that stamp are determined by your nationality. That's why I use the word function in that sense.
Straight right line relationship what? Nationality to type of visa? No. Nationality to type of control of immigration control, but not to type of visa.
Well, the type of visa will depend on what you say is your reason for coming to this country. So that if you come as a visitor for a holiday, you won't need a domestic workers visa. But if you come here to work as a domestic servant, then your nationality will determine your migrant status in due course.
What determines your migrant status is a combination of your nationality and
yes.
your application being to be a domestic worker.
Absolutely. But it's a straightforward function of it. So the law determines the different ways in which you can come into this country.
If a Nigerian has indefinite leave to remain, is that a function of their Nigerian nationality?
Yes, because they will have had to have come into the country in the first place lawfully, or as an asylum seeker and then have it ex post facto legitimised.
They may have been born in this country.
If they're born in this country, they will still, if they have not got UK citizenship by birth, then they will have to apply for it in due course.
I only say you because you said they will have had to come to the UK.
I'm sorry.
Yes. So what I'm just trying to work out is if a Nigerian may have a variety of different immigrator statuses, each of which is a function of their nationality.
Yes.
How you make the link that you need to make to show that this is discrimination on grounds of their nationality.
simply by saying that it's a combination of their own personal factual circumstances and the way the law operates on their nationality. The nationality and the factual context within which they come into this country, or in your case, the example you've put to me, the way that they're born here, operates to determine what their specific, in their particular context, migrant status might be. My Lord puts to me the situation of indefinite leave to remain. Ordinarily, that will only arise after a period of 4 years of residency on other grounds. That would be the ordinary circumstance in which indefinite leave to remain would be given under the the House of Commons paper.
Well, or there might be a spouse.
There are other ways. There are other ways, of course. But each of those things are functions of their nationality. They follow through the way in which the law operates on their nationality and their own personal circumstances for why they should want to be in this country.
We are struggling a bit with this word function. Why aren't you saying that migrant status is a consequence of their nationality?
Well, I said earlier on, in prefacing my submissions, there are many different ways you can put it, but consequences, I'm quite happy with saying consequence. I'm afraid I just come from a mathematical background, and that's why I've used the phrase function. Well, it is a consequence. I'm sorry, my Lord Reed.
Well, I was just going to suggest to you that it's... well, one can say that it's, in causation terms, a but-for cause. I mean, obviously, it's a prerequisite.
Yes.
But it's not by any means the only cause.
And nor does it have to be in discrimination law. You can have a series of different causes for the circumstances which have to be identified as being the cause of less favourable treatment. But as my Lord puts it, if this woman had a British nationality, she wouldn't have been subject to visa control. If she'd had different nationality because she was Belgian, she wouldn't have been subject to visa control. But she had a particular Nigerian nationality, which had not, in her circumstances, amounted to indefinite leave to remain. And in those circumstances, she had to have visa control. So, as my Lord Wilson puts it, it was a direct consequence of her circumstances and British law and her nationality. It's those factors coming together. Now,
I mean, the difficulty I'm having at the moment is this, that really whether she's Australian, American, Colombian, or Nigerian, in any of those situations, she's a person who requires a visa to enter the UK. And the only reason why she is vulnerable to, why she is treated unfavourably under the Act, is that this individual has chosen to come here as a domestic migrant worker.
And that's the context of the case. We're not...
Yeah, so is it enough? Is it enough under the Act that there is this but-for causal element, even if it's not what's actually determinative of the unfavourable treatment? On ground.
My Lord, in answer to your case, I'm going to submit this, and that her nationality was determinative of her visa status in the context of her coming to this country to work as a domestic servant. And it's not relevant to consider the situation of an Australian coming to work in a bank on a different kind of work permit. It's just not relevant. The context of this case is domestic service. And whether you use the word function or consequence or anything else, her nationality determined the fact that she had to come here under the particular visa which was operated to control her in these circumstances. I can't put the case any different from that because that's it. That's actually how it worked in this case. And what I am going to say, though, is what I think went wrong in the Court of Appeal, we'll look at the judgment later on, was that Lord Justice Underhill's reasoning became more expansive than was relevant and necessary for the determination of the case. It's not necessary to think about the situations of persons who are coming for a different reason or to do different kinds of work. It's sufficient to say, in her case, it was her nationality. Now, I want to, if I may, just help put a little bit of focus on this.
Sorry, can I? Lord Reed looked at the matter in but-for terms. Do you suggest that but-for causation is enough?
The ultimate question that's got to be answered is was the treatment on grounds of nationality? That is it. And the but-for test is often helpful in circumstances where a benign motive is advanced by a discriminator to explain what they have done.
Well, I mean,
the classic... My lord, I'm sorry.
No. I mean, one could take, I think, a case where intuitively one would say but-for is simply not enough. The Equality Act protects a number of protected characteristics. One of them is religion or belief. Now, supposing a school of a particular religious persuasion employs a head teacher of that faith and then sacks them because...
Catholic school, Catholic head.
And he gets sacked for some reason or another. Now, if he weren't a Roman Catholic, he wouldn't have a job and he wouldn't be being sacked. But nobody could possibly say he was being sacked on grounds of his religion. Now, I mean, that's an extreme, if you like, silly case, but it's simply illustrative that you've got to show, I think, something more than that, but for the protected characteristic, they would not have received this treatment.
Absolutely so. And I'm up for the task. Yes. But, my lord, one way of looking at this, can I just deal with but-for a second and then immediately answer your point? The but-for approach, I think first came in the Birmingham Schools case, where in order to get, I think it was adduced by Lord Leicester in the Birmingham Schools case, it was also advanced in the James Neasley case. The Birmingham Schools case, girls had to get a higher grade to get into grammar schools in Birmingham than boys did. Birmingham said, because we've got fewer places. Yeah. And the but-for question was advanced in that situation. In the James Neasley case, swimming pool, and you got in free at pensionable age. And what happened was the but-for case, the but-for test was adduced. What really was going on in each case was to look at the operative factors. What was actually operating to distinguish the treatment of men and the treatment of women and the treatment of boys and the treatment of girls. And the answer was there was a gender difference in the schools case and a gender difference in the swimming pool case. So the but-for question is a question about operative cause. In your situation that you put to me, it's obvious that it's not an obvious operative cause of the dismissal, the fact that he was employed as a Catholic in the first place. If you look in this case, it is an operative cause of the treatment that this woman was here and working for these men, these families, under a visa which was a consequence of her nationality. Yeah, it's an operative cause in that sense. It's different from your school's example, because in the school's example, the woman merely gets the job because she's Catholic. But you haven't posited in the hypothesis that you put before me that her relationship with Catholicism's got anything to do with a dismissal. But if there was something that was concerned with the extent to which she believed in an aspect of the tenets of Catholicism, then it might be, but it might be different. In this case, the recruitment and the treatment are all part of the same thing. She can't come into this country unless each of these two appellants can't come into this country without the visa, but equally, the visa determines what they do and how they do it. And this is very neatly exemplified in the second case of Onu, where the contract of employment expressly said that Miss Onu was to hand up her passport for the duration of the work, and that she would not leave employment before the end of the 1-year period of the visa, and the passport would only be handed back at the end of the period. So that, if I can put it this way, shows that it was operating throughout the period of employment in a detailed and significant way. It may be helpful to just show you the findings on that in the judgment itself, and I'll just take a moment to do that. You'll turn to the T decision in Onu. And I'll show you the passages that deal with the control over the contract of employment. Paragraph 35 in the judgment, which I will rashly suggest is page 227 or 90. 227 in the electronic version. There were, in fact, two contracts deployed in the Onu case. So there was one contract which was offered to the High Commission in order to secure the visa. And you'll see that's discussed in paragraph 32. The contract was never given to Miss Onu, and there's a finding later on that she didn't know what was in it, although she did sign it. But that was done in order to secure the visa in the first place. And then 33 through to 35. Turning to the evidence of Mr. Akwiwu, the reason why the tribunal didn't accept its evidence of conflict the claimant, and then you can see that there was issues over the documentary evidence. 34. The respondents called Mrs. Akwiwu's mother, Mrs. Chucks Okoye, to confirm that the claimant was treated well in the UK. In her witness statement, Ms. Chucks Okoye made no mention of the contract, this is the first one, which was relied upon by the respondents, as showing that they provided a statement of terms and conditions. In the course of cross-examination, Ms. Chucks Okoye described herself as an attorney practicing in Nigeria, confirmed to counsel that she drafted the second, that is, contract of employment. She gave evidence that the contract had taken a day or two to prepare over a period of time. Significance, in the tribunal's view, that the contract by Clause 1 requires the claimant to work for the respondent for not less than 1 year, bearing in mind the visa has to be for a 1-year period, and by Clause 6 prohibits the claimant from leaving or absconding from the employers and their family before the expiration of that time. It also provides that if the claimant reneges on that clause, the matter should be reported to the UK police and immigration authorities. The final stipulation in the agreement is that it may be terminated after the expiration of the period of 1 year by either party giving 3 months' notice. And Ms. Chucks Okoye then added the words, and her personal passport number so-and-so returned to her. It was her case that Miss Onu was insistent upon that clause being added. It was common ground that the contract was finalised. And essentially what they decided was that that was a constructed contract. But those were the terms on which Miss Onu worked in this country. And they all directly link into the visa terms, which I've shown you in the memorandum prepared by Mr. Milsom. So it's quite different from the hypothesis that you put to me. The visa was central to the contractual control of this employee, Miss Onu, in this case.
Well, that's fair enough, Mr. Olaigbe. I don't think anybody doubts that the visa vulnerability was an operative cause of the treatment. The question is whether that means that the nationality was a ground of it.
My Lord,
that's where we are, isn't it?
Absolutely so, and I've got to come into that, but I wanted to answer Lord Toulson's question because it's important. I would invite you just to note the last few lines of paragraph 35 on the next page. And you can see that there wasn't any other explanation that was advanced that how they dealt with that. It was held to be that this was the way in which the exploitation was exercised. You see the finding at the end of that paragraph was through the control of holding the passport. And bluntly, my Lord, if I can just say to this, what greater badge of nationality is there than a passport? A passport is itself a badge. It states in terms, all our passports state in terms what our nationality is. So that's why I've used, in a way, the word function rather than merely consequence. It was the method of control in this case. It's made absolutely explicit in the ONU contract. In practical terms, it was the same in the Taiwo situation. I think I need to get into the authorities and to have a look at those. And I'm going to do them by reference to the case in Taiwo for obvious reasons. And I'm going to start in a slightly different place because, on reflection, it seems to me that I can make the point very neatly by saying it's not just me that takes the view that this is direct discrimination, but it's also the UK Borders Agency itself. And if you would turn to the case at page MS 82, paragraph 69, you can see that we've set out the code of practice from the UK Borders Agency. Now, before I get into the detail of what it says, it may be helpful if you look at the page handed up with the yellow tab, which explains the purpose of the UK Borders Agency Code. Putting it very simply, it's an offence under the Immigration, Asylum and Nationality Act 2006 to employ people in this country who are in jobs outside what their visas permit them to do. But there are statutory defences if the employer has carried out proper investigations before recruitment. The detail of that you don't need to know in any greater form than that. But the Immigration, Asylum and Nationality Act assists employers by giving a code of practice. And the purpose of the code of practice is set out and its content in paragraph 23. The Secretary of State shall issue a code of practice specifying what an employer should or shouldn't do in order to ensure that while avoiding liability to a penalty under Section 15 and while avoiding the commission of an offence under Section 21, he also avoids, and originally it said contravening the Race Relations Act, it now says the Equality Act, or in Northern Ireland, the Order. Before issuing the code, and then you can see wide consultation with the relevant bodies, and you can see that it's laid before Parliament after considering representations. Now, of course, it's not the force of law, but you are required, as with all statutory codes in this context, if you were dealing with an employer before you, you would be required to take it into account. The code itself is in authorities at tab 60. That's bundle 5. if you'll go to page 2087, the purpose of the code is set out in paragraphs 2.1 through to 2.3, and I don't need to read those through to you again because I've summarised those to you. And then on page 2088, your responsibility as an employer under the law. Under Section 4 of the 1976 Act and Section 6 of the Northern Ireland Order, it's unlawful to discriminate. And it then sets out what I've summarised to you. 3.2, direct discrimination means treating people less favourably on racial grounds. And then it gives examples. Examples include, fourth bullet point, where an employee with limited leave to remain in the UK is given a more degrading form of work to do in comparison with workers with unlimited leave. So they hold in the guidance that to distinguish between visa applicants and those on ILR would be race discrimination. Now, you may disagree with that, but it supports my case because it's a function of nationality in each case, whether you've got ILR or whether you've got a visa control. Now, I'm as aware as any advocate that arguing from consequences is dangerous. But
you're going to do it, yes.
I'm going to simply say this. There does seem to be some rather practical good sense in the guidance given by the UKBA, because it does mean that if somebody is lawfully within the country, then they are treated equally, provided they have come through an ILR gateway or a visa gateway. They're treated in the same way. And it therefore provides for the kind of equal treatment that we within this country would expect of employers. In short, there's practical logic in that. We think it's correct in law and make that submission to you and pray it in aid. Parliament also, having approved that, would seem to be on our side. I can press that point too far, and I'm not going to say more than that. Can I now take you through the authorities which we've cited in the case? The first goes some distance. It doesn't go the full distance, and that's Morris and Westminster City Council. It's tab 30 in the authorities, which is in volume 3. This is a case which is in the volume of authorities, both at first instance and also on appeal, where the point was assumed in favour of the individual. I say immediately, because my friend will say it against me, that this is not a case about the Race Relations Act, it's about Article 14 of the ECHR. And it's concerned with whether a legislative provision which differentiated in the treatment of homeless persons by reference to immigration status was capable of being found to be unlawfully discriminatory, Article 8 taken with Article 14. Mr. Justice Keith, in fact, gave two judgments in this. If you'll go to paragraph 1 on page 1148, 867 in the judgment at H, G to H. For present purposes, the following passages in my earlier judgment set out the background. The issue
what's the page reference to?
867 in the in the authorities, in the law reports, 1148 in the MS bundle, the electronic bundle.
Thank you so much.
Between G and H, foot of the page. For the present purposes, the following passages in my judgment of the 26th of May set out the background. The issue which this case originally raised was set out in the introduction to an earlier judgment which I handed down. Homeless persons are regarded as having a priority need for accommodation if they have dependent children living with them. In that event, the local housing authority has to ensure that they're provided with accommodation. If If they don't have priority need, the local housing authority may secure accommodation, but it's not obliged to do so. The question which this case raises is whether a homeless person has a priority need if unusually the child is subject to immigration control, but the parent is not. And the conclusion was that the legislation which excluded such persons was in breach of Article 8 and Article 14, and in this case a declaration of incompatibility was given by Mr. Justice Keith. You can see that there is a greater identification of the nature of the immigration control over the page 1149 between letters E to G, in reaching the conclusion that the claimant's daughter's immigration status was decisive. The Housing Authority relied on Section 185 of the Housing Act, which provides, sub 2, a person who is subject to immigration control within the meaning of the Immigration Act is not eligible for housing assistance unless he's prescribed. So that was the clause that operated in that particular case. And then if one turns forward to paragraphs 17 through to 19, the discussion of how that operated worked out. But as I say, Mr. Justice Keith's conclusion was that this was immigration control amounting to a form of nationality discrimination within Article 14.
The offending paragraph section is it 185.4 at the bottom of 1149?
I'm grateful to my lord.
Is
I've
that
taken
right?
it quite quickly. Yes, it is.
Yeah.
I've taken it for.
No, that's very helpful.
Now, it's fair to say that that case did go on appeal, and you'll see the appeal judgment at tab 33, MS 1241. And the Lord Justice Sedley and Lord Justice Old were in agreement as to the outcome. There wasn't a further debate about this. It was accepted that Article 14 together with Article 8 were engaged by the Secretary of State, represented by David Panic. I don't think you get much more from that, and bearing in mind it's an Article 14, Article 8 case, I'm going to take this swiftly unless the court wishes me otherwise. So I'll move on from that to Rogers, which is at tab 35 in the bundle. This is the first of two submissions which are essentially based on the Crime and Disorder Act of 1988. And before I get into that, if you have my case open, that's at page 81, it may be helpful just to take paragraph 67 before going to Rogers. My lady, there's an error in the case. We've referred to section 24 of the Crime and Disorder Act. It should be section 28. The Crime and Disorder Act made provision for racially aggravated legislation, racially aggravated acts to be treated differently and to be the subject of specific indictment and with specific penalties. And it used exactly the same definition of racial group. And there are two cases, Rogers and an Attorney General's reference, where it's interpreted and applied. So if I now go to Rogers, this was an early judgment in relation to its meaning. Essentially, what happened here was the defendant, Rogers, met with three young Spanish women when riding his motorized mobility scooter along the pavement. And he called them bloody foreigners, go back to your own country, and there was an incident.
He
I don't think the facts
pursued them into the takeaway.
I was going to say, the facts don't get much more mundane than that, do they?
It's racially aggravated threatening behaviour.
Exactly. I mean, the image of pursuing the Spanish women into the kebab shop mixes more... more
culture.
I'll stop there. And perhaps unsurprisingly, the House of Lords concluded, and you'll see my lady's judgment there, cited in our skeleton as to how Section 28, subsection 4 should be addressed. Section 28, subsection 4 is actually set out in terms in paragraph 7 of the judgment, which you will find at page 1337, 66 in the internal numbering of the judgment. As I said, it specifically replicates the racial group definition that we've already seen in the Race Relations Act, including citizenship. The passage from my lady's judgments at paragraph 12, my memory is that she gave the judgment of the court, I think. And
Well, we didn't have such things in the House of Lords. Was this the House of Lords?
I think you gave the sole judgment of any length.
It's the only judgment.
That's the accurate way to put it. We weren't allowed to have judgments.
You're quite right. And the discussion at paragraphs 12 through to 18 seems to us to be entirely apt. Having cited the legislation, my lady's judgment adopts the submission for David Perry, instructed for the prosecutor, saying, and in reference to the group language that has already been said, that a flexible, non-technical approach makes sense, not only as a matter of language, but also in policy terms. The mischiefs attacked by the aggravated versions of these offences are racism and xenophobia. Their essence is the denial of equal respect and dignity to people who are seen as other, deeply hurtful, damaging, and disrespectful to victims, and so on, damaging to the community at whole by denying acceptance to members of certain groups, not for their own sake, but for the sake of something they can do nothing about. And then you go on to say, at G, fine distinctions, depending upon the particular words used, would bring the law into disrepute, and you discuss the difference between wogs beginning at Cali, bloody wogs, tinted persons, and so on. Now, we've cited that for a particular reason, because if you look at race discrimination in the context of colour rather than nationality, you will, our submission, be informed about your approach to nationality. The point about colour is it has infinite different variations, from white to black, through yellow. If you're a Celt, you may have red hair. There are an infinite number of different variations. And people may take objection to one aspect of colour rather than another. So you don't get into a discussion about colour as an aspect of race, saying, is it an objection to all aspects of colour, or is it enough to have objection to a specific aspect of colour? In this situation, it was put in a different way. It wasn't put as colour, it was put as being bloody foreigners. But bloody foreigners is an aspect of immigration status and nationality in general terms. You don't need to drill down as to whether they're foreigners who've been here 1 million years, foreigners with indefinite leave to remain, foreigners who have got work permits, foreigners who are asylum seekers. None of those things matter. The purpose of the definition in race is to address the treatment of others differently from the way that, in this situation, people who were British and not foreign would be treated. So while I quite understand the questions that have come from the bench to me about aspects of nationality, drilling down as to what particular bit of citizenship, what particular type of nationality, what particular circumstance in which it arises might be. Understand the questions, I would suggest to you that the approach taken in this judgment looks to the overall effect without requiring you to disentangle every aspect of it and say a person who takes a point about nationality might treat others of the same nationality in different circumstances differently if in the particular circumstances nationality has been operative in the way in which the treatment has been afforded. It doesn't finalise the case, but in our submission it informs the approach to nationality.
One can get
Nationality is an aspect of race.
One can get into arguments about operative and function. I wonder if there's a risk of this becoming overcomplicated. It seems to me that the case you're really advancing is essentially a simple one. Whether you can advance it consistent with the authorities is what you're now examining. But if you just take the language of the Equality Act, a person discriminates if because of a protected characteristic, A treats B less favourably, you say that in this case the cause of a detrimental treatment was so intimately bound up with their nationality that nationality should be regarded as part of the grounds of the unfavourable treatment. The nationality wasn't background but a central feature of the cause of the treatment.
My Lord, I'm totally happy to adopt that approach.
Now the question is that you could say, well, that is a plain person's reading of the effect meaning of the statute. We all know that because of questions of causation can be a very difficult area of the law. You've got that which is background, you've got that which is effective, central, significant. And courts have to choose between what is background and what is integral. The question then is, if that is essentially what you're saying, whether cases like Appellant say, no, that's not good enough, there has to be a complete mirror fit.
Well, I'll have to get on to Pat Malnice in a moment, and if your lordship will forgive me, I'd rather not anticipate how I'm going to go there too quickly. Mm-hmm. But what I will say about Pat Malnice now, because the reason for that is I want to get through these other cases here. But what I will say...
But have I grasped the nub of your case?
Absolutely, my lord, you have.
Right.
But Pat Malnice is about a different class of case. It's called a criterion case because what happened in Pat Malnice was not where one was looking at, if I can put it this way, a personal interchange between two people. You were looking at the operation of a legal rule set out in a statute, which divided people into sheep and wolves, people who did or didn't get a particular benefit. This case is concerned with actual interaction with individuals. It's, in that sense, factually messier. And the way that you've put the point to me, you have to get to grips with what the treatment itself was in this case. In Pat Malnice, the treatment can be reduced to a sentence. In this case, it takes a bit longer to do that.
No, usually exercising leverage over somebody by holding onto their passport is pretty close to exercising leverage over them by reason of their nationality, of which the passport is a badge.
My lord, exactly so. But it's a longer, because in the sense you have to then actually see what the findings of fact are that underpin that bring you to that point.
When one does, in the Taiwo case, the emphasis is on personal characteristics of the appellant, her poverty, her lack of resources of various kinds, which rendered her vulnerable in a way in which, for example, an Australian nanny, or for that matter, a better educated Nigerian woman from a better off background would not have been so vulnerable.
Yeah. No, my lord makes a different point, I think, from the one that Lord Toulson's made. In Taiwo, the factors that led to the vulnerability are discussed at greater length. And her lack of English, for instance, her personal poverty are explored more greatly. There are two ways into this, into how you address those. The way that you can look at it is to try and disaggregate every aspect of the vulnerability. And I would have to accept that poverty by itself is not a consequence, operative, function, or whatever it is of nationality. It may be associated with it, but poverty is a universal fact. Illiteracy falls into the same category. But even if one takes that approach, which was the approach taken by Mr. Justice Langstaff in the Employment Appeal Tribunal, of disaggregating all those factors, nevertheless, the control is exercised in her case through the passport. Of that there is no doubt, and there's a clear finding. And that's enough. The fact that she may be vulnerable on different grounds and for different reasons is simply makes the overall vulnerability the greater. But it would be quite wrong in our submission to say that somebody who is vulnerable for 10 reasons, one of which is race-based, lacks access to the Race Relations Act or the Equality Act because of the 9 reasons which are not race-based, if the 10th reason, which is race-based, is significant and plays an operative part, is part of the base facts, and so on. And the facts in Taiwo make it quite clear that the passport itself was used as a tool of control over her. So that's my answer to my lord.
Your position would be the same if the appellant happened to be a young Australian woman who was, because of her personal characteristics, equally under the sway of her employer and had handed over her passport to her employer.
Yeah. I mean, it could be, it doesn't have to be a poor Aboriginal. It could be a poor Greek from Sydney who happened to be illiterate, or a poor Syrian, perhaps more commonly nowadays, from Sydney, or it could be a poor English person or Irish person, for that matter, by ethnicity coming from Sydney. It wouldn't make any difference. If the passport itself is used as the tool of control in any material sense, that's enough. And it's why you'll have seen in the submissions we've said that, that we think that, in a sense, we said Lord Justice Underhill had overanalyzed the case by reference to Pat Malnice. It might be said he's underanalyzed it in a way, but that's what was going through my mind. I've mentioned Rogers. I want to take you to the Attorney General's reference, because we think that's a very helpful case too. That's tab 32 in the bundle, which the court will find in bundle 3, and it, I'm afraid I don't have the MS number so quickly. Tab 32, it's MS 1232. These cases are full of strange facts. This one seems fairly strange too. The defendants took her child to see a general practitioner, but was unhappy with his assessment of the child's symptoms. The doctor suggested that she find another doctor. She replied, "I can't find another doctor. All the good doctors are taken up by asylum seekers, and I'm left with an immigrant doctor." She then grabbed the letter he was writing and in the struggle caused several small scratches to his head, and she was subject to a charge of racially aggravated assault. The judge ruled that the word immigrant was too wide to constitute membership of a racial group and directed an acquittal. And that was the basis of the reference to the Crim Div. And Lord Justice Auld, sitting together with Mr. Justice Beatson and Mr. Justice Wakeley, gave the judgment And having set out the facts in paragraphs 1 and 2, 1233 in the MS bundle, the point of reference, Her Majesty's Attorney General now seeks the opinion of the court by way of a reference on the point of law whether the use of the word immigrant to a victim of an offence is capable of demonstrating hostility based upon the victim's membership of a racial group, namely a group of persons, and then the definition. Put shortly, the central issue arising on this reference is whether the use of the word immigrant in its simple application that a person is non-British is specific enough to denote membership of a racial group within its meaning in section 28.4. And cut a long story short, it was submitted that was too wide by the counsel assigned by the registrar for the acquitted person. The discussion is in paragraph 10, setting out the submission made for prosecuting counsel at trial. And you can see the judge's approach. In the course of an exchange of views with prosecuting counsel, he said that the word immigrant constituted a vast racial group with no specific characteristics. The concept of nationality and national origin are not wide enough to include the concept of non-British nationality or non-British national origins. The words immigrant doctor in this case could be interpreted as a reference to someone who couldn't be understood to speak English, the conclusion at which he had arrived having heard Dr. N giving evidence, and then the ruling is set out. And the submissions from the Attorney General are paragraph 12 on 1236. And the submission was put immigrant is within national origins and nationality. And then the intervention from Lord Leicester pointing out the inclusion of national origins in consequence of Ealing and the Race Relations Board at 14 through to 15. And paragraph 15, Lord Leicester's submission, which seems to have been adopted. More generally, Lord Leicester urged the court, as various of the judicial authorities have indicated, to avoid a strict or legalistic approach to the construction of the term racial group in this context, which requires a court to decide, amongst other things, whether an accused has behaved towards another in a hostile way, in the sense of reflecting adversely on his and then the various different definitions of race. In the context of this case, he submitted that D's use of the term immigrant doctor towards N was clearly capable of being a demonstration of her hostility towards him on racial grounds. And they accept that approach. You can see it at paragraph 24. We adopt and apply that reasoning to the broad, non-inclusive term immigrant doctor in the context in which it gives rise to this reference. If anything, the non-inclusive term foreigner denotes membership of an even broader racial group. As Lord Leicester observed, the judge erred in determining the matter simply as a matter of construction, whether D's use of the term immigrant doctor towards N was only an allegation of non-Britishness or a demonstration of hostility, in a sense, didn't matter. It should have gone to the jury. So that was the approach that was taken. Now, in one sense, that's different from this case, of course, because the focus was on the use of the word immigrant at the point of assault. But it's not so far removed, and the approach, which is non-technical, saying here that you don't need to parse immigrant in the context of this proposition, helps me. It shows that when you're looking at the word race as defined within the legislation, you don't need to parse down every aspect of a person's asserted nationality to work out if it is at the edges of the word or beyond it. So we say that supports the case that we've taken. The next case that we put forward to you is that nationality can include also simply being non-British. So you can define nationality in an entirely negative way.
That's not disputed.
I don't think it can be.
No, well, it isn't.
And the Privy Council has made that point, it's obvious. So I don't necessarily need to open it, it's cited within the case. But again, it supports my point, because what it means is that you don't need to define exactly what bit of non-Britishness a person has. You don't need to get into the detail of that part of it. We also draw to your attention the fact that there are statutory exceptions within the Race Relations Act when immigration control decisions and rules are introduced by government. Those statutory exceptions are both in the 1976 and 2010 Act, and that's paragraph 73 and onwards. It would be surprising if it didn't have such a control. And I accept immediately that it could be argued that those exceptions would be necessary for cases of indirect discrimination only. It could be argued that, but that's not how the defences have been legislated. They've been legislated generally to cover both acts of direct and indirect discrimination. So I do draw that to your attention. If you go to page 532 in the MS bundle, and I'm just not entirely sure what page that is. That's in volume 1. In fact, it's tab 1 in volume 1. And towards the end of that tab, I think we will find section 19. We found some of these anyway. We get section 17. Sorry? We've got 19D. We seem to have omitted section 17. We'll make good that at some point and send it in. But there are a series of...
I've got section 17
Yep.
Have I omitted it?
on page 532.
532. I'm sorry, I've got the right reference in my notes and opened the wrong page in the bundle. 532, yes. This is a very good example. Section 17 applies in relation to race discrimination so far as relating to nationality or ethnic or national origins. Section 29, that's the public service, the service provision in the Equality Act. Section 29 doesn't apply to anything done by a relevant person in the exercise of functions exercisable by virtue of a relevant enactment. So a minister of the Crown acting personally or a person acting with a relevant authorization, and then the relevant enactments are all the immigration acts that you would see. So
what's the point you're making here, Mr.
The point is that the statutory operation of immigration control is carved out of the Act. The implication is it would otherwise be within the scope of the Act. And the implication being, therefore, that immigration control is an aspect of race through nationality. My Lord Wilson would just note section 17.1. You can see the context for the carving out is in relation to race discrimination on grounds of nationality, ethnicity, or national origins. Now, it doesn't prove the whole point. It's possible to have a carving out which is entirely redundant, but it does rather suggest that it was contemplated by Parliament, that it was necessary to do that. It reflected, in fact, provisions in section 19D of the 1976 Act, and you'll find 19D in page 502 at tab 1. not quite in the same terms, but exactly, well, it is very similar terms. I think it's just set out differently. Does the court have 19D? I don't think I need to read it further. There's one European law case, Firma Ferrin, which we've referred to at paragraph 77. And this isn't going to determine the way in which this case goes, but it does lend support to the argument from the approach taken by the Court of Justice. It's tab 54 in the bundle, which is in volume 5, which I've lost. The case concerned a very simple set of facts.
I'm sorry, Mr. I'm
Page 1851, tab 50,
Van Canson.
54, volume 5.
Thank you very much.
I've done that in the wrong order. Volume 5,
All
tab
right.
54.
Got it.
And page 1851.
1851.
What's your shorthand name for this case, Mr. Allen?
Firma Ferrin is what it's normally known as.
Firma Ferrin.
I always like to have a go at European languages, but I'm afraid Dutch and Flemish are beyond me. The issue in the case was very straightforward. The equivalent of the Equality and Human Rights Commission, or at least a similar body in Belgium, brought proceedings against a door manufacturer who, when recruiting, said in public statements that door fitters would not be recruited on the basis that they were immigrants. The jobs were not open to immigrants. And the question was put in really essentially two different ways. Was that within the scope of Directive 2000/43? The point being, at that stage, the commission involved, the Centrum, couldn't point to an actual victim. And the court had absolutely no hesitation in saying that this involved, that statement was evidence of, as they put it, race or ethnicity discrimination. You can see the first question is at paragraph 21 on 1864. Paragraph 21, I don't need to take you through the reasoning. The conclusion is at 28. And then...
Well, 21 is the no victim point.
Exactly.
Yeah. But where is the immigrant?
They put it let me just find the page.
I mean, do they in fact discuss?
I mean, it's really taken by assumption in the judgment itself, which is why I've said it's of limited help to you. But except that the fact that the statement was being a ban on recruitment of immigrants. Sorry, the best passage is perhaps of paragraph 25 on 1864. But,
Well, it equates the statement with certain ethnic or racial origin.
It just does it by assertion, without any developed argument at all. As I say, I don't think it will resolve the case in front of you, but it certainly points in the same direction.
My lady, in the interest of saving time, can I just mention paragraph 31, which may help you on in due course when I make my submissions.
Okay.
Thank you very much. So those authorities, we say, all point in the same direction that we have suggested supports the approach that we have taken. And I think that probably takes me to the Court of Appeal's judgment and the way that they dealt with the matter. We dealt with this in our case at paragraph 78 and onwards, page 85, the MS bundle. And it may be helpful to have the judgment to hand as we go through this. I know this can make it difficult for those working from the electronic bundle. The Court of Appeal's judgment starts at page 144. And the reasoning is to be picked up at page 159, paragraph 40. And there's a discussion which needn't bother this court about whether because of or on grounds of is the right way into the question. Under the Race Relations Act, on grounds of was used. Under the Equality Act, because of was used. And there's no doubt at all that Parliament intended them to equate. They had to equate because the Race Directive used the phrase on grounds of. It was thought that because of might be more accessible. And so the question was posed in paragraph 41, or the two questions were posed. We have no objection to the way in which these questions are posed, but I just take you to them before we look at the way the discussion develops. The question, therefore, is whether the claimant in either case has established that the mistreatment found by the ET was on the grounds of her nationality. I note by way of anticipation, it's not necessary that they show that their nationality was the only ground for that treatment. It's enough if it's a significant part. Both tribunals made explicit findings that the claimant was treated in the way that she was because of her status as a migrant domestic worker and her consequent vulnerability. For short, because of her immigration status. But that gives rise to two questions. Can those findings truly be treated as findings that their immigration status constituted the grounds? And B, if so, can their immigration status, in the sense identified above, be equated with their nationality? I needn't take you through the answer to A because we take no objection to it at all. The court...
Well, the answer was yes, wasn't it?
The answer was yes, and quite rightly so. We say, if anything, 4 paragraphs was more than enough to reach that conclusion. The submission that was not accepted, and I used a slightly different phrase, is paragraph 48. We said, Mr. Milsom and I, and Mr. Rowbottom adopted this, that immigration status, in the sense used in this case, and nationality are intimately associated. Now, we've had a discussion this morning about other ways of putting the point. Those were just our words. And that being so, discrimination on the grounds of the former should be treated as discrimination on the grounds of the latter. And that was the submission that was not accepted, and it's that part of the reasoning that we now need to address. I don't accept that submission. It's now well established that discrimination on a particular ground will only be treated as discrimination on the grounds of a protected characteristic if that ground and the protected characteristic exactly correspond. We have to think a little bit about how that operates, and I will come back to that, but we'll look at the reasoning that is adopted. That was decided by the Supreme Court in Pat Malnice. That case concerned provisions in the legislating relating to the state pension, which limited entitlement to persons habitually resident in the common travel area, broadly the British Isles. No one could be treated as so resident unless they had a right to reside in the common travel area. Such a right would be enjoyed by all UK nationals, but there would nevertheless be some UK nationals who nevertheless did not qualify because they were not habitually resident. The issue was whether those provisions constituted unlawful discrimination on grounds of nationality, contrary to the governing EU directive. Now, before we get into the discussion of other cases, Bressol and so on, which will follow, it may be helpful to say that the members of the court in Pat Malnice would have been minded to disentangle two provisions, one of which they held was directly discriminatory, and all the court, as far as I recall, thought it was directly discriminatory, and one which was indirectly discriminatory. And they decided, following Bressol, that they had to take the compendious approach of putting all the conditions together, and therefore that it was indirect discrimination. And we shall see that point of argument being developed. The Supreme Court, following its reading of the decision in Bressol and the opinion of the AG Jacobs, of Advocate General Jacobs and Schnorbers, held that the provision was indirectly but not directly discriminatory. The reason why they were not directly discriminatory was that there was no exact correspondence between the protected characteristic and the criterion used in the provisions, although it would be much easier for UK nationals than others to meet the habitual residence requirement, and not all would do so. See Lord Hope and Lady Hale. We'll go to the decision in a moment. And that was in line with James and Eastleigh, which is the swimming pool case, and Elias, which you may or may not recall, is the case in which, in order to get a particular lump sum payment from the government for having been interned during the war in Hong Kong, you had to have been born in Britain or the child of parents born in Britain. In the former, direct discrimination is found because there was an exact correspondence between gender and pensionable age, and in the latter it was not found because there was no exact correspondence between nationality and place of birth. There is no such exact correspondence in the present case. It's essential to remember that the ground on which the respondents were held to have discriminated was specifically that the claimants were migrant domestic workers with a peculiar dependence on their employers, and is a consequence of that status. See paragraph 41. That is what Mr. Allen and Mr. Ilson were acknowledging by referring to immigration status in the sense used in this case. To say that their immigration status in that sense is intimately associated with their non-British nationality, or as the tribunal in Onu put it, that the two are linked, is to say no more that only people with non-British nationality are migrant domestic workers. That is obviously so, but what matters is not that all non-British nationals working in the UK are migrant domestic workers or share an equivalent vulnerability. Very many non-British nationals working in the UK whose conditions of leave to enter or remain permit them to work freely and entail none of the peculiar vulnerability of those whose right to work is in practice dependent on their current employer. Now, I do pause there for a moment because in our submission, paragraph 50 does not focus properly on the case that was before them. It poses the case in a general sense of migrant status. But when these two tribunals were discussing migrant status in this case, they weren't doing it at large. They were talking, because that's what both cases were specifically about, the migrant status associated with being a overseas domestic worker with an overseas domestic worker visa. And that context gets lost in this paragraph. The paragraph here addresses migrant status as some generic concept, simply as being somebody who is subject to migration law. The context of this case was not migration as general, but migration in the context of into domestic service.
But the Court of Appeal is obviously of the view that discrimination here requires the general approach.
I agree. And we say that's wrong because it's not the context of the case at large.
Well, what they're saying is, I think, Mr. Allen, whether they're right or not is what we've got to decide. But what I think is this what they're saying? That if you focus simply on the domestic worker visa status, you are not speaking of nationality, and that is demonstrated by the fact that plenty of other nationals with different immigration statuses will not have the same vulnerability.
Well, I don't actually think that is how the case was put,
all right.
with due respect. What I think has happened here, and I submit to you, is that, and I think it's an understandable error of approach, but because we developed the case around the point of immigration status, in argument, those were the two words that were used rather than looking at the specific context. And I think what happened was that Lord Justice Underhill therefore took them in a generic sense rather than in the context of a particular work context, which was the subject of the dispute.
Well, what about the last sentence of 50? None of the peculiar...
But that's precisely the point, because that focus is concerned with work at large within the UK, rather than specifically in the context of being a domestic worker. It only makes sense to us if you approach it from that point of view, because, putting it simply, you could be an EEA worker, I accept that. You could be a European Union worker, and you would be a free mover. But if we define nationality in the negative sense, enlarging it to be non-British, non-EEA, or non-European citizen, you have to have the domestic worker visa to do this job. You do.
To do this job.
To do this job, you either have to be an EU citizen or an EEA citizen, or you have to have the visa. So the visa does operate, if I can put it this way, to distinguish between the two categories of worker for this particular job.
Well, you could do the same job with indefinite leave to remain, or with... It just so happens that this particular sort of visa is available in particular circumstances, but you don't have to employ this particular worker to look after your children, clean your house, and cook your meals.
Well, my lady, I have to accept that point. Of course, it's true. What I'm trying to say in paragraph 50 is that the focus has been enlarged far too widely, and it's the generic approach that has been taken by Lord Justice Underhill to migrant status at large. Indefinite leave to remain doesn't, if I can put it this way, it has different aspects of control that are associated with it. People can lose indefinite leave to remain. We simply didn't explore that category here, because that part of the argument, I think, was not addressed. Then we get my counter-argument in paragraph 51. I sought to distinguish Pat Malnice on the basis it was a different kind of case from the present, and I went back to JFS, and we will look at JFS in a moment. Lord Justice Underhill said no relevant distinction. It's true that Pat Malnice was not concerned with the provision of domestic law, but with the prescription of discrimination in an EU directive, and I don't suggest for a minute that's the basis of a distinction. The relevant principles are the same, and the members of the court referred indifferently to the EU and domestic case law on the nature of discrimination. Pat Malnice was indeed since been applied in Predium Bull. I appeared in front of Lady Hale in that, and I think possibly some other members of the court. I'm not sure whether Lord Reid was in it as well. Or
Lord Hughes and Lord Toulson.
I beg your pardon, I haven't done the analysis, but I thought it was so. It's also true that Pat Melny's was a case of discriminatory statutory criterion in which no question of the mental processes of the putative discriminator arose. But I can't see why that should make a difference. I'm going to submit to you that, yes, that does make a difference, that there is a difference when you have, if I can put it this way, bad motive, where proved bad motive is in place, then I do suggest that a different kind of comparison is relevant.
Trouble is, bad motive, for your purposes of your argument, means discriminatory motive.
Well,
as defined in that,
lady,
presumably.
That would be a tautologist submission, and I don't want to make that. I think there is a true syllogism here. The bad motive is the ability to use the visa to control the employee, to suborn them to an abusive employment relationship. That was the bad motive. The question then becomes, is that discriminatory? And that depends on whether you say visa equals nationality sufficiently. So it goes back to the submissions that I've already been making. I'm puzzling you. I don't mean to.
No, I'm...
But that is the way that we see the syllogism operating. In short, bad motive, intending to abuse the individual by misusing factors associated with the immigration status of the individual. And those factors are an aspect of her nationality. That is the syllogism. Therefore, we say it's on grounds of nationality. I don't need to go through paragraphs 52 and 53. And there's a difference of approach between the Court of Appeal and the Employment Appeal Tribunal in approaching the facts of the case. Although it's not quite explicitly said, there's no doubt that the Court of Appeal accepted our submission that Lord Justice Langstaff had disentangled the vulnerability from the immigration status. So and I'm happy to pitch my camp on what the findings are at first instance. There is a reference to Mehmet, and Mehmet is disapproved that, as you can see, simply in paragraph 55, and you won't get anything particularly from Mehmet, although it's there, and given precious of time, I don't propose to open it to you. And then no discussion of the need for hypothetical comparators in paragraph 56. So that's the way in which the Court of Appeal dealt with the matter. Just dealing with the point, perhaps, about Mr. Justice Langstaff's judgment, and going back to my case at paragraph 81, or paragraph 75 of the judgment, when Lord Justice Ryder added his comments, the Court of Appeal were entirely persuaded that the vulnerability arising out of the immigration status and the mental processes led the respondent to act in the way that they did. So I don't understand that to be subject to criticism.
As a matter of interest, do you say that Mehmet was right or wrong?
We say that it's inadequately reasoned. The outcome was right.
Thank you.
So if I go back to paragraph 81, that passage in Lord Justice Ryder's judgment is undoubtedly correct and was certainly agreed by Lord Justice Maurice Kay, and I think is implicit in the approach that Lord Justice Underhill took. That is a conclusion that incorporates the vulnerability of the claimants arising out of their immigration status and the mental processes, which led the respondents to act in the way that they did. The respondents used the opportunity presented by the vulnerability of the claimants to mistreat them. And that, in a way, quite neatly brings me back to the context, because the context that Lord Justice Ryder is looking at is the context of this working situation. And what one can see from this is that he is finding the bad motive of mistreating the vulnerability that arose from the immigration status in order to mistreat. One can therefore, if you want to take a comparative approach, you can ask the question, would a person with a nationality that did not give rise to this immigration status have been treated badly by these persons? And the answer is obviously no. They would not have had the tools with which to mistreat them. They might have been mistreated for different reasons and in different ways, but they couldn't have done it in this way. It's the consequence of the particular immigration status that these women had that was the grounds of the mistreatment. It gave tools to the employers to suborn them to their will in the way that's described in the two judgments. So Lord Justice Ryder comes back to context, to the specific context. Now, I think this is the point at where we have to look at what's the difference between bad motive cases and Pat Malnice type cases, where the criterion is operative. In gender cases, it's sometimes said discrimination is binary. If you advantage men, you disadvantage women, and so on. But race cases are not binary in that way. You can be very affable towards people on a whole range of different race-related bases, but only take objection to one part of a race ground. Disability is another place where it's not binary. And don't start me on age, where it's even more complicated to address.
We've no intention of so doing.
But the danger of the Pat Malnice approach, where you have a rule which has a binary application, either you're within the rule or you're outside the rule, and applying that universally across all race-based grounds creates difficulties. The prohibition in the direct discrimination text is, as Advocate General Moraes Maduro said, it's exclusionary. The treatment of the individual should not take into account their the protected characteristics. That's the purpose of it. And if you intend, in some way or another, to take into account some aspect of the protected characteristic, you're breaching the terms of the provision. If it's done on a motive basis, it becomes much more difficult to treat it to a kind of Pat Malnice kind of approach. Because the discriminator isn't looking at questions of whether or not there's a binary decision. The discriminator is simply saying there's a particular aspect about you, which is a particular protected characteristic, which causes me to act badly towards you. That's what happened in this case. That's the way in which this case, we say, should be analysed. It's a bad motive case, and once the bad motive is analysed, that's enough. It is intrinsic within that motive that nationality of these two women is at the heart of what happened to them. There is a lot of law that has discussed questions about good motive and bad motive and whether good motives can rescue otherwise discriminatory acts. There's a lot of law about the extent to which you need to take a comparative approach. The place where we pitch our tent is in the line of authority, starting with Lord Nichols and Nagarajan, adopted in JFS, but also more widely discussed in JFS by Lady Hell, but more widely discussed and adopted generally by the majority in JFS, that there are certain cases which are actually obvious, where the motive is seen to be wrong. If the motive itself is a prohibitive ground, that's enough. And that's what we say this class of case is better seen as. It doesn't beg a detailed comparative discussion. Indeed, the whole comparative discussion becomes more and more complicated. As we've seen from the debate today, we get involved in arguments about exactly what the circumstances within which the comparative assessment has to take place. Is it domestic workers? Is it immigrants at large? Did they mean immigrants at large when they used that phrase? In fact, what we see here is that it's a particular context in which the bad motive was operative. So once one approaches it from that point of view, we say this case is perfectly obvious. It would be extraordinary, we submit, and I know one can challenge any submission which asserts in this way that it would be extraordinary if the outcome were otherwise.
How do you define the relevant motive in this case?
The relevant motive in this case can be nuanced between the two different cases because the family situations were slightly different. But if I try and universalize it for the two cases, the bad motive was that they wanted to be able to have, in each case, to have a servant who they could completely control to serve them and their families, irrespective of the free will of the individual and the labour code that supported that. Quite a neat way of putting it, I think. There's quite a lot contained within that, and it's slightly different between the two cases. But I think that's as apt a way as any of summarising it. The family situations being slightly different, and the amounts of money that were paid in each case being slightly different. But that, I think, supports it. I'll just ask to the right. Is that okay? And Mr. Milson makes the point that it isn't actually just about the right to work, it's also about the right to reside in the UK because of the taking of the passport. So it's freedom of action through the passport. Can I take you to JFS, which is at tab 38 in the authorities? My lady, I've just noticed the time.
Yes.
Would it be better to start to deal with, can I complete JFS, or I'm not sure?
Well, why don't you get as far as you can? You've 5 minutes to get as far as you can with JFS.
So tab 38, which is in bundle 3 in the authorities. And I think in this case, my lady, I think you were the only of the current composition that was in JFS. I suspect it's been cited to the members of the court, but may I summarise the facts very shortly the Jewish Free School would only admit, I beg your pardon, I think it gave preferences, yes.
Well, if they were oversubscribed.
I was going to say, once they were oversubscribed, they would only admit those who were described as Jewish by the office of the chief rabbi. And simply put, you only were Jewish by reason or within the view of the office of the chief rabbi if matrilineally you were descended by somebody recognized as being Jewish by the office of the chief rabbi, or you'd undertaken an Orthodox conversion. And so there was a particular kind of Jewish ethnicity at the heart of the office of the chief rabbi's definition of being Jewish. And E was was the daughter of a man who was Jewish within the OCR definition, but whose mother had neither converted nor was Jewish within the OCR definition. And the question was whether it was direct or indirect discrimination.
Or at all.
Or at all. And it may be right to say this, that standing back from the case, it was important for the office of the chief rabbi, and indeed the Jewish Free School, to be able to show that it was indirect discrimination, because that would enable them to put forward an argument of justification. If it was direct discrimination, they couldn't do that. There was no statutory possibility of an accommodation between Article 9 rights and the Race Relations Act. And it was one of the earliest cases in which a conflicts of rights situation within the equality framework had to be considered. One of the ways in which the argument was put forward for saying this is better seen or properly seen as indirect discrimination was on the basis of the religious motive of the office of the chief rabbi. And so what the office of the chief rabbi said, and the Jewish Free School, was that because we see our motive as being religious, it's not to be seen as falling within the Race Relations Act. And therefore it was the interface between religious identity and ethnicity. All this had been discussed earlier in a case called Mandler and Dow Lee, where it was held that somebody who was a Sikh, it was the concept of ethnicity was discussed in relation to Sikhs, and it was recognized that a religious identification could be part of an ethnic identification. Now, the passage which is in My Lady's judgment, which we've cited, is at page paragraph 64 at page 1400. And I'm going to pick it up just a little earlier in the passage from paragraph 61 and following.
Well, would you like to pause there?
Of course.
As you've introduced the case, you've got us to the bit you want us to look at, and we might as well do that at 2 o'clock. Court is now adjourned.